So in terms of cloud law 2.0, where are we in terms of the law and those legal issues I mentioned earlier? Well, what is clearly noticeable over the last 6 to 12 months is that there's been a shift in the attitude of businesses towards the law. And I think this has been driven by, I guess, a common understanding by providers and purchasers alike that one of the shortcomings, one of the obstacles with the cloud has been these contracts which are providing weak undertakings. And that's been, and the issues around data protection. So it seems now there's a shift by the business community. And what we're seeing now is that providers in the cloud are now, in addition to competing on cost and service levels, are now starting to compete on legal contracts in relation to cloud services. So basically what before was seen as an obstacle is now being seen by vendors as an opportunity, because they're recognizing that, if we provide not just good services from the cloud at a low cost, but if we provide legal assurances and couple those services, well then that's really going to increase our ability to sell. So coupled with that, and from a legal perspective, this is rather fascinating, because often, the terms and conditions are something that happen at the end of a procurement process, and it's sort of just the annoying bit where we have to bring the lawyers in to close the deal. But now it seems that the legal terms and conditions are being dusted off right at RFT phase, and people are selling their services on the basis of, look, we have quality terms and conditions in place. So as I said, the choice from a purchaser's perspective is now improving, in that they can buy products on an as-is basis, but now there's products and services available from the cloud whereby they are being coupled with decent legal warranties and undertakings. Similarly, from a regulatory perspective, and in particular from a data protection regulatory perspective, the regulators are starting to zone in and consider cloud computing issues. The law hasn't systemically changed, and it doesn't systemically change overnight, but the practice of regulators is evolving. So I want to just give you an example of what I'm talking about in terms of vendors competing in terms of legal terms and conditions. It's a contract which has got a lot of attention in the kind of the legal cloud contract community, an obscure bunch. But essentially, the municipality of LA recently tendered in terms of its entire desktop system, emails, storage, and Google won the contract. And I guess the city of LA have become a type of a marquee client for Google. But what's interested is the reasons they won the contract. Obviously, cost was important, obviously quality of service. But what Google, from the outset, in terms of this competition, they sought to make their legal contract part of their product offering right up front. They pushed it out there. So even though lots of sensitive records are going to move because of this contract, including, say, the LAPD email system, a lot of its storage systems, a lot of criminal records are going to be moved out to the cloud. The city of LA got sufficient assurances from Google to do this. So as I said, their sales pitch wasn't just about the quality of services and cost, it was also about the legal offering. As PC World here quoted that one of the reasons they won the contest was because they offer the best contract and legal protections, which begs the question then, what are these legal terms and conditions which vendors are starting to offer, which gives them the competitive edge? Just to give you some examples of this contract, which was made publicly available, so it was obviously used as a bit of a marketing ploy, a bit of a coup for Google. They said, firstly, the city, the municipality, the purchaser of the services could cancel at will, so there wasn't this long-term lock-in. Second thing, they said there'd be audit rights, granted through a third party, but audit rights of the security systems of Google were permitted. Similarly, Google promised, which again, this is becoming quite a standard vendor promise, in that they cannot release or view data of their customer without prior approval. Again, they promise penalties for loss of service, and interestingly, unlimited liability for security and data breach. So they zoned in on what the key purchaser concerns are. And they said, rather than excluding liability, they said, well, look, if there's a breach, you can sue us on an unlimited basis. So they're the type of, that's an extreme case, obviously, because the terms there, firstly, were a differentiator, so that's what's very new and interesting about it. The question is it an exception? Was that contract signed because it was the negotiating power, of the second largest city in the US isn't the same as the negotiating power of a small public body in Ireland with 20 people involved? But it is relevant in that it shows that, how there is this shift, and vendors are starting to take legal contracting and see it as a bargaining tool. I wanted to, having given that sort of key example, I want to then just look across other vendors and see, just note it, see, is this shift a one-off, or is this shift generally occurring amongst vendors? Microsoft, in terms of their Azure offering, are also sort of moving in the right direction. And a review of their contracts will see that the type of service credit offering they're offering has evolved significantly, in that it's now no longer a case of getting extra days if there's downtime, but you're getting real service credits. Similarly, there's limited warranties being provided in conjunction, not extensive warranties, limited warranties. But as I said, that's a shift from where we were 2 or 3 years ago, when a lot of these products, albeit some of them were at beta level, were being provided on an as-is basis. So now one can update these products knowing that there's some limited promises. So as a business user, you're being given these promises. Similarly, on the whole security front, there is promises and undertakings in terms of the implementation of reasonable security measures. So the important thing as a user is that if you're engaging with this type of provider, if something goes wrong, you have legal recourse. As I said, with the earlier contracts on an as-is, there was little, if any, legal recourse. Google Apps Premier, again, what you're finding with the providers is that it's invariably the products that you're paying for that you're going to get some form of legal cover with. And again, Google have focused in on the whole confidentiality, seeing that as a key concern. And they're giving this undertaking that they'll protect users' confidential information and clients' confidential information on the cloud in the same way that they'll protect their own confidential information. And that's a pretty high standard, obviously, when you look at the vast warehouses and data which Google would store itself. Again, taking this cap of liability from the LA contract, they're applying this now in their Google Apps Premier T's and C's, where they're saying that if there's a breach of confidentiality, you can sue us and we're not capping our liability. And similarly, they're giving a fairly basic warranty around compliance with their SLA. So obviously one has to be very cognizant as to what the SLA says. Looking at a more domestic example, Hosting 365, one of our domestic kind of providers of cloud-based services and solutions. Again, if you take a look at their contract, which is publicly available, it's not an as-is contract. I mean, obviously you're paying for the services, but they're promising a basic level in that the services will be provided with all due skill, care and diligence. It's a pretty standard and basic commercial warranty, but it does enable recourse if something goes wrong. So it's not an as-is contract. Similarly, they're agreeing in their contracts that they'll comply with SLAs. With 365, along with a lot of other providers, there are still legacy provisions whereby they tend to suggest a fixed-term contract of a certain period. And obviously, when we get to the optimum cloud solution, it'll be simply you'll be purchasing and drawing it down on an as-is basis, and you're not being locked in for a fixed term. But as I said, the shift is occurring in that both international big players and Irish players are starting to provide legal protections which give a lot more comfort and confidence to the purchaser community. So basically that's the key idea, if you like, the first key idea I want to address today is that in terms of legal practice in the cloud 2.0 is that there is a shift, and vendors are now starting to compete in terms of the service they offer. And the other point from a purchaser's perspective is that not all vendors are the same. I mean, some of Amazon's big contracts which they're using for signing up the bulk of their customers are still of that old type, if you like, with very, very broad exclusions, whereby invariably, the quality of service may be very good, but it's not matched with a quality of contract, so there's a great deal of exclusions. So as a purchaser, one has to look across legally, in addition to looking at price and quality of service, security, you can look at the legal contracts and say, well, what are we being offered here?